stand. We appreciate your attendance. Good evening, ladies and gentlemen. I'm Alvin Gillard, the Director of the Baltimore City Community Relations Commission. There are a few other folks that I would like to acknowledge. All of you are important. We certainly appreciate your attendance here tonight. But there are several organizations that are sponsors of this event tonight. And I'd like all members of those sponsoring organizations, if you would just stand, because many of them come as far away as Howard County, Montgomery County, Baltimore County, and they wanted to be a part of this event. So those members of the sponsoring organizations, would you please stand? Thank you so very much. And one more acknowledgement. I'd like to acknowledge my predecessor, the former Director of the Baltimore City Community Relations Commission, Mr. John Ferran. John. We have a truly august panel assembled here this evening to participate in this look back, this reflection of the Civil Rights Act of 1964. So I won't tarry, I'll introduce each one of them, and I won't try to list all of their accomplishments because there's simply too many for me to list. But these are great men, strong men, men who participated in the struggle, and men who are willing to tell us a little bit about the stories that brought us to where we are now. So it's my pleasure to introduce to you this evening Mr. Michael Mitchell, the son of Clarence Mitchell. Michael Mitchell, for those of us from the Baltimore area, and not necessarily just those of us from the Baltimore area, because he has been a civil rights giant for the entire nation. Mike served in the Maryland State Legislature, and he has a wealth of knowledge about the role that his dad played in the passing of the Civil Rights Act of 1964. Judge Kenneth LeVar Johnson is a retired judge from the Circuit Court of Baltimore City. He presently serves as the hearing examiner for the Baltimore City Community Relations Commission. Judge Johnson hails, I believe, from the great state of Mississippi. And to have an opportunity to sit down with Judge Johnson for just 5 minutes or so, you walk away with a tremendous amount of knowledge and you feel empowered, because Judge Johnson has a great story to tell, and he's also a great storyteller. So we're happy to have with us this evening Judge Johnson. Mr. Woody Grant is presently the Chief of Quality Assurance and Compliance for the Maryland Department of Education. He was also one of those individuals who was out on the front line. He was a partner with the Mitchell family in demonstrating, marching, a great activist, and he also has a story to tell, Mr. Woody Grant. And last, certainly but not least, probably now one of the most prominent attorneys in Baltimore City, and not just civil rights attorney, but attorney in the greatest respect of what attorneys should be about. Dwight Pettit's name is synonymous with championing the underdog. Dwight Pettit probably has a few bucks now because he's won some big cases in the city of Baltimore. I mean, agencies are closing because of Dwight Pettit. Not fair. But he's a tremendous attorney, but he's the type of individual that's willing to give back. And I think that's why he jumped at the opportunity to participate in this forum this evening. So we're tremendously proud of Dwight. As a matter of fact, Dwight's dad was a plaintiff in one of the cases that really helped to frame what the Civil Rights Act of '64 has come to be about, and Dwight was the attorney for his dad. So ladies and gentlemen, Mr. A. Dwight Pettit. And now, whenever you assemble a group like this, you have to have someone to sort of steer them along and keep them on track, because they just have so many stories to tell.
We're going to go to Mr. Grant and then Mr. Pettit, and then we'll open up the, I'll start off with some questions and we'll open it up for the audience.
You're seeing the linkages of engagement. Mr. Mitchell and Mrs. Mitchell were our attorneys. When my wife and I sued the Board of Education in Harford County We all celebrated in 1954, 17 May, when the court declared that schooling was unjust. However, as an educator, as a student at that time, however, we were still segregated. We were in de jure schools, schools that the state of Virginia, my home state, said that black folks and white folks cannot go to school together because of the inferiority of the blacks. Virginia, the cornerstone of massive resistance, found itself in lockstep with the courts that said that Brown would be implemented and with all deliberate speed. In 1964, the Civil Rights Act promulgated and kick-started what should have started in 54. Schools were not desegregating. Schools today are not integrated. There are folk who have understood, because of their lack of knowledge, that we are integrated. We're not. The continuum was segregation, desegregation, and then integration. We've not realized the outcome which the law was passed to do. We've not done that. In our state of Maryland, for instance, Baltimore City Public Schools were the very first public schools to desegregate in 1955. Not one other school in the state desegregated its faculties until 9 years later, its student body, until 9 years later. The last public school system in this state who became so-called desegregated happened in 1978. Now, Brown passed in 54. Now, the question always comes to me, why aren't you people doing more about that? You know, civil rights did not get a stage in this country until we engaged the authority. Because of the lack of public engagement from African American citizens and whomever else empathizes and sympathizes with this whole notion of racism, the engagement has not been there. Thus, the law has not been implemented. We have enough law on our books to be walking hand in hand in this country. We should not have to sit in this room tonight to celebrate, as we are, a legal mandate that has not been implemented as it should have been. It has not in this state or any state in this union. This state required black people to be taught by black people. White people who taught black people were jeopardizing their very safety. Understand, you've heard two historians, frankly, Judge Johnson and Michael Mitchell, give us wonderful history of where we come from. We know where we are. We're still a ditch. And the question is, why? The question is, the reason we're there is because we've gotten comfortable. Yeah. We've allowed ourselves to be lulled to sleep by tidbits. You heard what the Constitution said. You heard what the first Civil Rights Amendment said. Why is it that we don't live out the truth of those amendments? Folks, we have got to become engaged. We have got to get off our rear ends, get in the street with people. First of all, you have to increase your knowledge about what's going on around us. How dare anybody tell me they don't vote? How dare anybody tell me that we don't vote? The only reason our vote shouldn't count is what happened in Florida 4 years ago. We have things to do in this country. We can ill afford to sit around and allow ourselves to be second-class certified as we've done, folks. We got to get involved. There is a levy in a number of families in this state, in this city, in this country. They're dying out because the young people have decided that there's no need to fight anymore. The need has never been greater than today.
Yes, sir.
When we lived through something that I never thought I would live through, first time I paid poll tax in Virginia to register to vote. Yeah, we paid capitation taxes. They didn't want us to, so they caused us to pay. We had to pay for the registration that we were allowed to participate in. Don't ever, when you get to be 16, is it 16 or 18? 18 years old, you make it your business to go wherever you can and vote. And if you're 18 and sitting in this room right now and you are not registered, in my car, I have a stack of registration applications. I can register you tonight. It's very important. This civil rights, 1964 Civil Rights Act was a blessing in disguise. It caused much to happen in terms of education in this country. We were not following the Brown decision to any appreciable degree statewide until 1965, until 64 rather. And then in 65, we had promulgated Title IV of the Civil Rights Act, which then allowed the Congress to appropriate money to school districts who were willing to desegregate, because the excuse was, as you've heard today, in many newscasts, an unmandated regulation is not one that often gets implemented. If you tell me what I need to do and you don't give me the money to do it, don't come trying to make me get this thing done. It doesn't happen that way. And then Title IX of the Education Amendments of 1972, which said that young females should be given the same access as males in the country. And there was the Rehabilitation Act of 1973, which said disabled individuals should be given access, accommodations, so that they then could become a part of American life. Title I of the Elementary Secondary Education Act in 1965, which was promulgated to make certain there was money so that those dumb black children who were poverty-stricken would be able to get the kind of instruction in elementary schools that they deserve. That hasn't happened yet. That hasn't happened yet. We have been about the business of trying to get curriculum in this state particularly implemented from a multicultural perspective for almost 30 years. The law has been on the books since '72. However, no one has been willing to say, this is what must happen in your classroom. And they are willing to get away with that because we have not engaged our schools in our communities to make certain that they facilitate whatever measures are necessary so that they are in compliance with the law. We cannot afford to sit back and wait for people out of the goodness of what we think is their heart to welcome us into the fold. It ain't gonna happen, folks. It's not going to happen. We have too many children who are being satisfied with a GED now, unwilling to stick in school to graduate. Excuse is, I was kicked out. Okay, why were you kicked out? Who did it? So-and-so did it. What was the reason for having that done? Groups in our community should engage the administration of your local school. Find out why things that are happening, or else they will continue to happen. We have seen matters go from good to worse. in a matter of a few years because people in our communities have not taken the interest to ask the questions why.
That's right.
Ask the questions why. Mr. Mitchell came out of what he came out of, not because he sat back and waited for someone to invite him. He asserted himself in an aggressive kind of way. We've got to do that, folks. We've got to do that. That's the only way we're going to make it. Black boys, for instance, are at the bottom of every statistical measure that there is in education. Kindergarten through year 16, the fourth year of college. Why? Not because they're dumb, not because they're stupid, not because they're naturally violent, not because they're prone to be drug addicts. No. There are reasons behind their responses to what's happening to them every day. We need to ask questions. Ask questions. There are groups out here who are willing to help. I am a strong believer in the NAACP. Some folks have given up. I'm sorry that you have. It still works when you work it. You can't sit back on your rump and expect glorious things to occur. It just doesn't happen. And it never ever will. It never will. Look at what happened to Dwight's father at Aberdeen Proving Ground. They would have continued to treat George Pettit the way they did until their son, who his father educated, went back and asserted himself, engaged the system, and won.
Yeah.
Do you see? The Mitchells. Engagement. We've got to be about engagement. Don't let another 40 years pass and you're sitting around on your goodness waiting for stuff to come to you. It just doesn't happen that way.
Good evening, folks. As I sit here with these giants, I'm going to give you some additional history as to how they, in fact, affected my course and my involvement in terms of civil rights. I constantly say, and as Mr. Gilliard says, I practice all forms of law, particularly criminal, personal injury, wrongful death, but it all goes back and stimulates from civil rights, as I will very briefly try to evolve for you. I had the opportunity, the great opportunity, to spend the 40th anniversary of Brown versus the Board of Education at the Supreme Court of the United States with the Supreme Court justices. The reason that was taking place in Washington, D.C. is because they were honoring the assemblage of lawyers that had come out of Howard University, where I went to law school. Thurgood Marshall, James Naismith, Charles Houston, and on, that put the fabric of Brown together. And I say that to say, I celebrated this year at the University of Maryland, and I celebrate the Civil Rights Act of 1964 with you here tonight. Now, what is so unique about this and where we are tonight? I'm prepared to speak tonight. The thing that has gone back and forth through my mind has been the tie-in of all of this with Baltimore, Maryland. Now, that's not to in any way diminish the struggle that we knew that took place in Mississippi, that we knew that took place throughout the South and throughout this nation, the blood that was shared. But I said to myself, Baltimore has a very unique attachment to this whole movement, and particularly the Civil Rights Act of 1964. If you look at the roll call, and the other day I think I said on the radio, I said, Baltimore is, in my mind, to the civil rights movement that we might say Virginia was to the formation of the Constitution. And the reason I say Virginia, because that's where Washington, Jefferson, Madison, even though we go to Philadelphia, but the brain thrust came out of Virginia, if I'm historically correct. And if I'm not, I'm sure these gentlemen will correct me. And so when we move to Baltimore, Maryland, and we see that Thurgood Marshall came out of Baltimore City, We see that the first case that was the predicate for Brown was the University of Maryland in terms of integration of its facilities. When we see that out of Baltimore came Mr. Clarence Mitchell Jr. in terms of being the architect in conjunction with Lyndon Baines Johnson and Everett Dirksen and the others in the United States Senate that broke the filibuster, that was Baltimore City. When we see that Juanita Jackson Mitchell was not just a fighter in Baltimore City, but was nationally acclaimed as a civil rights freedom fighter for the NAACP. And this man sitting in the middle here, Kenneth L. Johnson, just didn't litigate in Baltimore City. He just didn't break down the Jim Crow in the fire department and Jim Crow in the police department. But this man was an attorney general for the United States and was in the battle and the struggle throughout Mississippi and the South. And so all of these people generated out of Baltimore City. But even further, I thought about it, I was on the radio the other day, and I said, but the Afro, and the Murphy family, and the Oliver family, which was in fact the mouthpiece of the civil rights movement across this nation, came out of Baltimore, Maryland. And so if you go down through the roll, in terms of the attorneys and in terms of the movement, we have a special place, in my opinion, in the history of the civil rights movement, and particularly the Civil Rights Act of 1964. And in summary, as we move on tonight, I am a product of all this. If I look back in terms of divine movement or divine direction and intervention, I had no choice but to be involved in the civil rights movement. Because as has been alluded to, my father moved to Aberdeen, Maryland when I was 12 years old. I was in the great environment of Turner Station, Maryland. I was going to Solace Point High School. I was involved in athletics. I had just started dating. I was having a great time. Never thought about integration, never thought about civil rights, just having a ball. One day my father comes to me and says, we're moving to Aberdeen. Aber, what? And so all of a sudden I'm uprooted out of Aberdeen and thrown, out of Turner Station and thrown into Aberdeen, Maryland, where there was nothing but deer, raccoons, and skunks. And none of us did I see on the military base. And the school was indicated, was segregated. Well, Mrs. Mitchell was my first lawyer with Tucker Durham, Jack Greenberg, and Thurgood Marshall, as Mike Mitchell alluded to. And from that, we began to pound away. I was a child plaintiff. I came back to junior high school in Baltimore and boarded out until the school was integrated. The school was integrated in 1960. I entered Aberdeen High School. And in 1960, before that really, my father was told that he would never be promoted again in terms of Aberdeen Proving Ground. And so he went he stayed at GS11, he was an electrical engineer, an electronic scientist. He stayed at GS11 for something like 14 years. I had the opportunity to go to undergraduate, Howard University. I had the opportunity to go to law school, Howard University. I had the opportunity to come back out and become a member of the bar in the state of Maryland. Another thing that I will indicate in a few minutes, it was another struggle. But I had the opportunity to go and take my father's case as indicated to the United States Court of Claims, where they awarded him $100,000 in back pay and remedy for the 14 years of his discrimination. And so then I looked around to come back to Maryland and practice law, and found out that the Maryland Bar was passing one of us at a time. One of us at a time. Maybe two. The percentages at that point in time, they were passing whites at a rate of 70%. If you went to the University of Maryland and you were white, you passed at a rate of 90%. If you were African American and went to the University of Maryland, you might pass at 20%. But if you came out of Howard University, the passing rate was something less than 5%. And I contacted through the Legal Defense Fund in Maryland, in New York, the Honorable Kenneth L. Johnson, who was at that time one of the most distinguished civil rights attorneys in the nation. And he brought, as I always say, not in religious sense, but we call it the trilogy in terms of the three cases. And one is Pettit versus the Board of Education of Harford County, Pettit versus the United States, and Pettit versus the Board of Law Examiners. And Ken took that case, and it was the first case in the nation to break down racism so that people could practice law across this nation. After Ken filed this suit in the state of Maryland with myself and the class plaintiffs, we found that there were 30-some other suits that were instituted throughout this nation. So my whole being and professional upbringing was involved around the civil rights movement. And as I came back to Maryland, my law partner would become Michael Mitchell and the firm of Mitchell and Pettit. And that's exactly where we started off. We took the first civil rights cases in this nation and in this state, and I dare to say we were winning more than losing. And one of the things that you asked, I hope you get back to the question and session as to where we are now and why we needed this legislation in consistency with what had been passed in terms of the 14th, 15th Amendment and what had been passed in terms of what they call 42 U.S.C., 1981, 1982, 1983, 1985. All of these were passed post-Civil War, as Ken Johnson was saying, so I won't repeat that. But there's a reason why all of this had to come back into fruition, and it's a reason, as Mr. Graham was saying, why we have to move forward from there to here today. Thank you.
Let's give our panel another hand. I've already learned a lot. I think there's mics on either side of the auditorium. If you have a question, just make your way up. The only thing we'll ask is that you limit your question to 30 seconds, because some people make speeches. I want to begin by asking the panel a question. I was in the 10th grade in 1963 November when John F. Kennedy was assassinated. And there's many legal scholars now that said had it not been for Kennedy's assassination, the Civil Rights Act of 1964, which was passed in July of '64, less than a year after Kennedy's death, would never have been passed. And I'd like to hear someone comment on that.
The statement that you made is correct. If Kennedy had not, unfortunately, been assassinated, we never would have had a civil rights bill in 1964, no doubt about it, because Kennedy did not have the political will nor the courage to pass the act. It needed someone who used foul language, drank bourbon, a few other things to pass it out. See, Lyndon Johnson was born in the hill countries of Texas. One of the things he was angry about in segregation and discrimination, and I still call it the perpetual racial curse of the Constitution. You see, every one of these so-called founding fathers owned slaves, except John Adams. Did you know that? And here they were running around talking about give me liberty, or give me death. You remember old Patrick Henry saying that? And we fought more hell than he ever fought in his whole life.
We'll be right back.